Okay.
Okay, I'm live here with Marcus, viewers victory number 5. He has preferred to be anonymous, so you won't be able to see his video, his image, but you will be able to hear him. One thing I wanted to talk about before we even get started is YouTube has discontinued the use of Google Hangouts for live streaming, and that means I had to learn an entirely new way in which to do one of these live streams, and I'm hoping that you guys can actually see us and that you guys can also hear us. So definitely post something in the comments if you cannot see us or hear us. If I start seeing comments that are talking about no video or audio feed, I'm going to end up trying to fix it within the probably 2 or 3 minutes, and if I still can't get it fixed, then I'll have to cancel the live stream and figure out what went wrong. But definitely don't blame us, blame YouTube, because they didn't warn us, they didn't send us an email, they didn't tell us they were going to discontinue Google Hangouts. We just found out very recently that they've discontinued. So it looks like Shay indicates she can hear me. So I'm going to go ahead and start. Again, I want to remind everyone that for anonymity purposes, Marcus has asked to not have his full name disclosed, to not have his image disclosed. And I'm going to go ahead and get started with having Marcus go into his story. And usually I'll interrupt people, but I think to let the live stream build up, I'm not going to interrupt him. I'll let him go on for as long as he needs to, at least for 5-10 minutes to get the numbers to build up in the live stream. And after about 5 or 10 minutes, then I'll start asking him more specific questions and see what I can do to pick out the particular legal, instruments, legal techniques that he used to actually get his outcome. But go ahead, Marcus, and first off, go ahead and let everybody know what your custody award is right now, and then go ahead and get into your story as to what it took you to get there.
Right. What's going on, viewers? Right now, my custody that I have now, I have primary physical custody with joint legal as of right now. And I just got that about a month ago. And before that, I was on pretty much a whole year of just having Saturdays just with my daughter, and then I also had to pay child support at that time. But I'll go ahead and start from the beginning. So basically, what happened was when I was in a different state, and I was in a different state, and what happened was the mother of my child was already in the system, so we basically had to fight for my daughter to get her to make sure that she didn't have to remain in the system. And so, soon as my daughter was born, my daughter was taken out the hospital and wound up living with the grandmother. And from there, everything seemed to be okay. And then I wound up moving to Georgia. And once I moved to Georgia, pretty much everything went wrong from that point. We wound up getting defects called on us. Well, technically called on her, and I just happened to be there. And we wound up breaking up. And once we broke up, she decided that she wanted to run with my child. And from that point, I've been trying to look for her, find her, because in Georgia you have to get legitimized, and in order to get legitimized, the you have to serve the other parent, which is the mother, because only men have to get legitimized. So since I couldn't find her and she was running, I had to wait until basically she decided to come after me for child support in order for me to know that she was officially in Georgia. And then from there, um, I pretty much put in a motion for legitimation and um, custody. And then on top of that, I wound up getting her served with the papers, which made it where she couldn't run anymore. Once we got her served, we had a temporary order where I basically had to pay child support, and I also only was able to see my daughter every Saturday. And then once the at that same hearing, the judge appointed us to have a guardian ad litem due to the fact that I was able to get an emergency hearing because I was able to get some defects documents that showed a lot of abuse, a lot of issues that was happening in the home, a lot of instability. And I was able to use those documents to be able to get the emergency hearing. And then within the emergency hearing, that's when I got the Saturdays. And from the Saturdays, at that same hearing, the judge appointed us to have a guardian ad litem. Of course, we both couldn't afford it, so we went on ahead and did the pro bono. Now, according to the pro bono, they was going to do it for free, but we was like at the end of the year where all the holidays was going to happen. So we knew we weren't going to get a guardian ad litem for months. So, but that was to me, according to my lawyer, that was a very good idea because that way we would have had somebody that can even further investigate on stuff that I couldn't even reach at that point. And then after that, we finally got a garden line appointment maybe around like 6 months later, 6, 7 months. And after the garden line was appointed, she did her investigation. And from that investigation, she felt from what she saw that I would have been better as a primary caretaker for my daughter than the mother at that time. And then that's now we hear from where we are now.
Okay, so there's a few. Took a few notes. The first thing that I'm curious about, or actually, the first thing I want to let the public know is, I'm speaking in our Nevada Judges Administrator mode there. The viewers. The first thing I want to let the viewers know is that apparently a legitimization action in Georgia is consistent with or similar to what other states call paternity actions. Does that sound right to you?
Yes, because basically what it is showing the course. Because the thing is, I guess in Georgia, it was a lot of people who's having to pay child support, and it wasn't a child, and they was getting sued. So now they're making it where legitimation is definitely on the forefront, and it declines in you having a paternity test or acknowledgement of paternity.
Yeah, and that's actually the same, I think, in all 50 states where only the male has to legitimize. The mother is just presumed the parent. One of the things I noticed is you weren't able to really get the ball rolling until she went after you for child support. And that's one of the things I think a lot of people struggle with because they don't know how to serve the ex that's hiding. And in your case, I wonder, did you have no clue where she was, or was it a situation where you had an idea where she was, but she was dodging service?
So what happened with us was we had literally no idea where she was. In
Oh, okay.
this particular time that we did get to see my daughter, it was always in a gas station or at a park, someplace where we didn't really know. And then she made it where the way places that we met at, it wasn't even close to where she lived. And then for one time, she actually did it at a what's the name? And then my wife was like, I think she's in Decatur. And when we figured that out, we were like, okay, cool. Then we'll kind of stay around in that area. But the person who did the serving, at first nothing was really in her name, and then she wound up moving, and the person of service that did it did a very good job and gathering information. However, he did it because she was also in the system as well under DFAX. So I don't know if he went to DFAX, got some information according to service. I don't know how he did it, but he did a very good job and found out where she just moved to and served it right at her front door.
Wow. So in my case, I had to deal with the same thing. My ex would never tell me where she lived, and it was so extreme that she got a fictitious address from the confidential address program. I think a lot of my viewers know about my ordeal with suing the Secretary of State and the publication that I won. And it's a common thing. It's weird because they won't tell you where they live, but they'll still let you see the child. They got to park for a couple hours here and there, at least until you sue. Once you sue, then you're done. You can't see the child at all until the court actually takes action. But how many years did you have to go through that sort of situation because you couldn't serve her? I'm just curious.
I went through this for about 3 years, maybe a little more, maybe a little less. And then within that time frame when she left, she also tried to put out a TPO out on me,
Hmm.
saying that I was dangerous. The first time she didn't show up because she just needed me to not be able to be around my child
Right.
for that 2 weeks that I had until I went to court. She didn't
Uh-huh.
show up.
Yeah.
And then 2 years later, she put out another TPO on me saying that I was trying to take my daughter from her. And
That's
it's so weird because when we went in there, the judge was like, "Okay, did he do anything dangerous in your testimony? Do you have any proof or anything?" And she said no. So she dropped it, canceled it, and then at that same court hearing, I let her know that I was coming after her. And I had another lawyer at that time that was trying to find her, and they couldn't find her. They didn't do as good of a job as the technically the third time I tried to serve her.
Okay, so one of the things I want to tell people, because so many people don't know about this, and nobody, a lot of the people who work at the courthouse, the clerks and such, they will tell you, well, you got to serve them, but they won't tell you about service by publication. Now, judges in these child custody and divorce actions, they don't like to do service by publication when it comes to somebody that you just have no idea where they are. It makes them really nervous. But in your situation and a lot of other situations, the person doesn't know where they live, but they still interact with them on occasion, especially if you're still getting text messages and emails. Facebook, if you can actually show that they're on Facebook, you can do service by publication, and it can make a judge a lot more comfortable with the idea if you include exhibits showing, hey, here's text messages from them, here's phone calls from them, here's a witness who came with me to an exchange. We know where they are, they know what's going on, they're just dodging service. Please let us serve by publication. And also, I will go ahead and email them, text them, and send them a Facebook message of the summons. When you do this, the family judges are a whole lot more comfortable with service by publication. You'll get it granted. And what that does is it allows you to serve them without having to play tag. Because some of these people, they just won't open the door. And they'll duck and dodge the server for years, just like happened in your case. So if any of my viewers, they don't know what I'm talking about, please go and watch the video Service by Publication, because I ended up having to do this against my ex once, and it works wonderfully. Once you get an order allowing you to serve them by publication, they can't hide anymore. They're done for. So that's definitely an option. And again, make sure you gather text messages and emails, because even though it's not required, it does make the family judges a whole lot more comfortable, because then they know, all right, this person really is just playing games. Here's some proof that they're trying to contact them, so I'm going to go ahead and allow service by publication, send the summons to them in a text message or in an email. It's a totally legal instrument. It's totally valid, and it's just a lot of people who aren't attorneys don't even know about it. And some attorneys don't even like to do it. They're lazy. So in your case, I wanted to talk a little bit more about the GAL. Did you have to wait a long time just because it was a free GAL? I guess my better question is, if you would have been willing to pay, would it have been something that you got a lot quicker? I'm just curious about that.
Yes. If it was money involved, where they would have had, because basically what they do is they make you pay into this like pot, and then somebody, I guess from my understanding, you pay the down payment into the pot, and then somebody looks at the case and they take it. So it's kind of like if the money was out there, we definitely would have got it sooner because the holidays wouldn't have really mattered. But when you have to wait pro bono, then you got to kind of wait till somebody actually wants to take the case. So it
Oh,
definitely would have been quicker if we would have made a payment.
okay. It sounds like it's probably a problem with, there's a lot of people who are probably in that pile. There's probably a big line too. So
Yeah.
one of the things that I liked about when you told me your approach to the GAL and your battle was that you put victory ahead of feeling good. And that's usually the way I describe the reaction a lot of people have to their ex, slighting them, disrespecting them. A lot of people want to react, and of course they have a right to do so, but it unnecessarily complicates the case, because then that person shows those reactions and you have to end up explaining yourself. And I just wanted to see if you could kind of give the viewers some insight as to how it impacted your case that you did not respond when baited, not just with the judge, but also with the GAL.
Yeah, and this is one of the big credits towards you on one of your videos, because I remember you saying that temporary satisfaction can definitely hurt your case in the long run, and I really took that to heart. So what I just figured out was like, okay, what I'm gonna do is I'm gonna look totally different in front of the guardian ad litem and in front of the judge, because that's what really and that's what really impacted the case, to be honest, at least in my situation, because when you are the total opposite from what the guardian ad litem is seeing on both parties, and it makes you seem more safe and sane, it makes you seem more of the more concerned parent, the best parent for the child. The guardian ad litem, it makes it a little bit easier for them to decipher from who is the problem person and who is not the problem person.
Yeah, that's exactly what it is. You make their job easier, guys. They're going to work. This isn't their, I hate to say it, but this is not really their passion. It's not really fun. what they do dealing with two bickering, grown-ups over, children, it's not something that they probably wake up in the morning and think, oh, I can't wait to go and do this for my job. And so from your perspective, of course, it's your life and it's frustrating, and you're angry, enraged, you're upset, and you have every right to react the way you do. But all it does is make their job harder. Now they have to look and see, why did you do these things? Is it justified? You're creating more work for them. And if you make their job as easy as possible, if you make the contrast as sharp as possible, it makes it's just they don't have to put in as much effort to come to the obvious conclusion that you're the parent that the child should live with. So make their job as easy as you possibly can by making the
Right.
contrast as sharp as you possibly can. And the
And
only thing better than explaining yourself is not having to explain yourself. Like
exactly.
so many people have all these explanations. They're like, I can explain all these things. You know what's better than that? Not even having to. Because
And you
you
know what?
go ahead.
And I want to kind of add to that for the viewers to know, because the thing about it is, when the one thing that you do not want to do according to a GAL is badmouth the other person. That's the one thing you do not want to do, and I'm gonna reiterate that, because when you're talking, and this is a video that I learned also from Alex too, according to Two Bad Parents. It also reflects that on the GL as well, because they're looking at y'all both as the same type of person. Then they're going to say, okay, well, it wouldn't really matter which parent is, the child is with. I might as well just keep it with the mother, because no matter what, they really want the child to be with the mother in most cases. But when you're totally different, and they don't view you as the bad parent, that's really making you look good as a person, and it could be vice versa. You know what I'm saying? You can have a narcissist according to a male figure, but if y'all both looking like a narcissist, that's not going to, it's going to cancel it out on both of y'all, because they're like, okay, y'all both is, domestic, or y'all both is narcissists, or y'all both are the same person. I need to find the difference so I can make this decision.
Yeah, there's actually experts that talk about that problem. A lot of times, the judges and the GALs come to the conclusion that most of the time it's two bad parents. And I even have a video on two bad parents. And there's expert reports that come out and say, actually, there's usually not two bad parents. There's usually one high conflict parent, and the other person is just reacting. And so what the report is doing is trying to get these judges and GALs to stop just jumping to that conclusion and try to figure out who that parent is. But like we both discussed, why do you want to take that risk and hope that you have a GAL or a judge that is wise enough to know this? Like, it's better to just play it
Exactly.
safe and actually remove that element from the equation. And one of the other things that I tell people is, when you're going to court for primary physical custody, there's serious issues going on. And the last thing you want to do is talk about other nonsensical issues, like, why did you send this text or email all, crazy sounding? It's better to be focused on, these are what's hurting the child, not so much, oh, let me explain myself, Your Honor. And after like 15, 30 minutes of that, the judge just turns their ears off. They're
Yep.
just done. They don't want to hear anymore. And when you're representing yourself, it's worse. Like, they'll
Yep.
listen to like your first three sentences, so you better make it good. After that, they're just done talking to you. So,
Oh, yeah.
can you tell me more about that emergency hearing? Because in Nevada, judges don't really, at least not where I litigated, they weren't fond of them. They denied them routinely.
Uh,
Okay, so hi, I'm Nolita. I'm Marcus's wife. With the emergency hearing, basically, when we put in for it, we stated everything that was concerning that was an emergency. As far as, when they first came to Georgia, he had temporary custody, and she ran off with him, with the daughter, within less than 6 months that they were in Georgia. So that actually still was in play. So kidnapping was a possible that we put on there, as well as um, uh, the, not domestic, but the daughter getting harmed or being in harm's way, as well as, possible, what was that? The UTIs that the child was catching. So possible someone was messing with her,
yeah.
as well as, It was kidnapping, abuse, neglect, um, and that she may be in danger due to the mother being married to some guy that was the possible corporate of all of this going on.
Yeah.
So all of that played a part in it, and at that point, in my urgency with me actually going in and crying about it, because now I'm like really feeling his pain, and certain things that I find out I wasn't able to tell him right away because I didn't want him to react in anger.
Yeah.
So with me personally going up there and talking to these people, personally going around talking to the director of the daycare during these incidents that they could have happened, with me actually face to face talking to defects people, face to face talking to the court people, they're guiding me to what I need to advise my husband to do. And they're telling me, oh, we're going to help you. We're going to help you. But I'm like, it's not quick enough. Y'all do not understand how far back this goes. And they really push the envelope to me to have, because me as a parent, a co-parent with him, uh being married to him, even though I feel like I should have some say so, I don't. So I had to support him and push him to do what he needed to do to make these things happen. So even though I showed my face and I showed my concern and I showed my sympathy and empathy for the whole situation, um, I had to make him give up time at work, time to do other things that he was trying to do, to make sure that we were prepared to go up there and actually show his face and show his concern and his fear for his child's safety.
Yeah.
Yeah.
Other
Because
people really don't understand it, and it's because they hear it all the time. So they just lump you into all the others. My wife would get all kinds of details from my son that I didn't get too. So was that a similar situation with you? Did the child talk to you more so than Marcus? I'm curious.
not really. She just very clingy to me and want to spend a lot of time with me and have a lot of fun with me. And I think that's due to, me being a mother as well, and her seeing that my grandchild and my children love my presence and love having fun with me. She doesn't necessarily get that at home. So she see the difference in the dynamic of how I am as a mom and a grandmother, and she wants that relationship, and she doesn't get that directly from her mom. Like, you have
Yes.
all these little friends that come over with daughters or whatever, but she doesn't have that same interaction with her mom per se.
It's
You know,
yes. Yeah. I go into
turning
deep.
cocktails on the lawn,
Yeah.
and and playing hula hoop and board games and reading books to her and coloring with her and painting with her. These activities, and baking cupcakes, with my grandson and her and my niece, stuff like that, she's not used to. She
Right.
wants to say that some of these things happen, but they actually don't. But she wants it so bad.
Yeah, and
So,
I think it even goes. I don't know about your situation, but if Marcus's ex has a personality disorder or severe mental health issues, it's even more. It's even deeper than that. There's a bond that's supposed to form between a mother and child that with certain personality disorders it doesn't form, and so it starts to connect with somebody else with a substitute, and it's just an instinct that a child has, and I don't know if that's going on in your case, but from what you're telling me, it might, and that is going to really cause the ex to panic, and it's not your fault. They just freak out and see that their child is bonding to other people. I don't know. I'm curious. Are you noticing that?
yes, very much so. Like, at first she would, put up this front, oh, I like her, but I don't have to like you, Marcus. And you'll never replace me as a mother. But it's never really been about me. It's just her wanting to be with Marcus. But I don't take that neither here into any type of whatever, because I know she has her problems mentally.
Bipolar and
But
sociopath.
with her daughter, it's more like she placed on her daughter to have a responsibility towards her feelings and her.
Yes, that's
So,
exactly it.
like, yeah, with
Yeah.
her, it's like, I want to call you mom in front of her, but I can't because it's going to hurt my mom. I want to spend time with you, but I can't express that to my mom. But her mom questions her so bad that she,
Yes, it's
I hear so
damaging.
many things about you. So I really doesn't have don't have a problem with you because
Yeah.
she speaks of you very highly, but yet you don't like me.
You know, when it comes to the line of questioning that it's more than just questioning. It's like it's unending. It's nonstop. I always tell people if you want to know how bad it is, watch my video. Secretly recording your ex, because it contemplates this case in Nevada. It's called a bid via bid, where a father recorded his ex and he caught her on tape with the questions that she asked the child. It's torture. It emotionally tortures them. And it's just they need their child to satisfy some emotional defect in them, and it becomes so desperate that it's like it's almost like that story of two people drowning and one person tries to save the other, and they both end up dying because the person that's drowning grabs onto them and pulls them under and kills them. It's this
Mhm.
it's like an animal instinct. They can't help themselves. They totally can't
Mhm.
help themselves. And it's akin to torture, psychological torture, emotional torture. There's a reason that the child is mainly with Marcus, and it sounds like the GAL figured that out.
Mhm.
So, um,
Yeah, did express that with her as well, that how she come off to me and try to play me against Marcus and tell me these things, but yeah, I know my husband. And
mhm.
then also it was, back and forth with her, and I was like, I'm not going to be placed in the middle. You want me to advise you, I tell you in front of Marcus, because I was divorced, but I didn't take my ex-husband through this kind of stuff. I didn't have these issues. You know what I'm saying?
Yeah.
I do not in between a relationship between a child and father. That has nothing to do with between the relationship that we had. And I tried to explain it to her in front of Marcus. But yet
Hmm.
she still, because the reason why she didn't catch on to none of that is because it had nothing to do with the child.
Well, I also think they, like I was saying earlier, they don't really have the choice. See, with us, we feel like, what are you doing? This is obviously wrong. You're hurting your child. Let's explain to you how it's hurting your child. They don't have a choice A and B. They can only do what they have to do to survive. They feel like it's a threat to their existence for the
Mm,
conflict to end. And so they won't stop. They can't help themselves. That's why I call them, sometimes it's like an animal instinct in them, and it's like you're trying to tell them to stop doing what your instincts are telling you to do. It's like you're telling them to stop being who you are. They attach their identity and their sense of self to this struggle. So if the struggle ends, they end. It's a real problem with them, and that's one of the things that frustrates me when judges and GALs don't get it, because they take this approach of, oh well, we just need to fix this up, we just need to tell you what to do, we just need to train you and educate you. No, that's not going to work. You just have to deprive them of custody. Once you find out that's what they're doing, that's what you have to do. It's like with the rest of us, we have this instinct not to do these things. We can see that it hurts our child. They can't. And if they can, then they justify it. They blame it on everyone else. So
yes, exactly.
one of the things that was really big with Marcus's case is the delay, and specifically that the problem was not resolved until the litigation came. And this is something that I tell my viewers a lot. So I was hoping that he or you, if you wanted to, could talk about that, because a lot of people think eventually this conflict will end. We just need to settle or mediate. We can push trial down. And I always stress the importance that that is actually going to make things worse, and that the sooner you get a deadline under their butts, the sooner you're going to get a settlement or you're going to litigate and win. I don't know. Go ahead and let the viewers know more about that.
So, and I just want to make sure, are you meaning the time from when I first served her until the actual primary custody is awarded?
Yeah.
Okay. So, the thing was, we didn't want this to prolong no further than it had to, but the delays that happened was only due to the fact of the guardian ad litem. Once the guardian ad litem basically got into play, that's when the first thing I did was I looked at the guardian ad litem like she was the judge, period. Because I felt like this is just how I felt. I felt like the judge appointed her due to this being a high conflict situation, and he wanted her to do his job. So all he had to do was make a decision. That's how I looked at it. So when the guardian ad litem came through, I did not have no no idea how long it was going to take from the time the guardian lotto came in to the end of her investigation. According to her, it was still going to be about a whole nother year after she got into when she was appointed as the guardian ad litem. But I think the judge kind of already knew where he was kind of going to go with it. He just needed somebody else to go in his same direction with the investigation. So it went from November of 2018. No, it was, what was it, like November or August, something like that.
Mhm.
So it was like August or September, something like that, of November when the case first started. And then the guardian litem didn't even come in until what, March of the next year.
Yeah.
Wow. So it doesn't sound like you had to deal with the problem that a lot of people have to deal with, which is that they have an attorney that just does not want to go to trial. And it doesn't sound like you had to deal with the judge who also just didn't want to go to trial, because the GAL was pretty much behind you on getting this resolved quickly. Is that what I'm hearing?
Yes, exactly. Because my lawyer at the time, like I said, she's a mediator. They wanted me to. Okay, I see where you're going with this, Alex.
Yeah.
Yes, they wanted me to mediate and settle this case so many times. And
Okay. That's
yeah,
usually what they do.
yeah, I see where you was going. Okay, I'm sorry.
Yeah.
So yes, the lawyer and her lawyer at the time, because the mother of my child also had a lawyer as well,
Mhm.
and she's a high profile lawyer, which means she um she deal with huge cases, and she do not lose.
Uh-huh.
So, and she wound up taking this case pro bono based on the information that the mother of my child gave her. So, according to the lawyer, she felt like this was about to be an easy situation, and she had no idea what she was getting herself into.
Mhm.
So, when I first put out my exhibits, I put out the defects documents as my exhibits. Period. So I guess what they was going to try to base their case on was I wasn't supposed to get those exhibits. Um, which technically I guess I wasn't, but I guess it was some type of intern that saw what was going on and was like, no, he needs to get this child. And I think people was helping me on the back end without behind the scenes, because the stuff that I was, for some, and I, like I said, I don't know how many viewers are religious, but I feel like God was with me every step of the way, make sure every turn was a progress turn, because the stuff that was happening in this case, it was kind of crazy. And then me just happened to come across your page, it's just crazy, because I was doing so much research, because I didn't even think I was going to have a lawyer in the beginning. I thought I was going to have to really do all this myself. So I was preparing as if I was going to have to do all this myself, and then I wind up getting help according to a lawyer, which the lawyer, I'm going to tell you, the lawyer was basically my face, but didn't really dictate the case. So it was basically, I just needed the lawyer at that point to help me with the documents and just make sure that nobody tried to take advantage of me. That was really all my lawyer really.
Yeah, there you go.
So, it was just that alone. And but yeah, my lawyer was trying to settle. She was trying to get my ex to settle. We went to mediation. That's kind of when everything went sour.
Yeah.
And on the back end of that, I just kept, I don't think that she really cared for me to be there, honestly, a lot of times, because a lot of things that she was trying to have him mediate on, I was against. I was like, no, because that wasn't what he deserved. That wasn't what the child deserved. That wasn't what the child
Yeah.
needed. And she needed less uh, connection with that person, which is her mom and that family, because of the things that was happening in that household and because of the things that was happening to her that no one knows anything about. So on the back end of that, that's why, even in Illinois, the people that was on that case before was able to give him, the head honcho gave him the information, and the mother just kept complaining because she was like, why is it he's able to get this information for Illinois and I can't get
Oh yeah,
anything?
and that was a big thing. That was a big thing
They wouldn't give
because
her nothing.
this what I would tell my viewers. Well, your viewers. I'm sorry.
No,
This is
you're
what I would
fine.
tell your viewers. Um, Get ahead of the game as quick as you possibly can.
Yes.
Do not allow the other party to start first, because what you want to do is you want it's I don't know how major it is, but somehow it helps you look a little bit better in the light, because it seems as if you're fighting instead of you're defending.
Right.
So I do want people to understand that if you're going to do it, be the first to do it. Just go ahead and get your case started. You start it. Don't let the other person start it. If you're dealing with a narcissist, you start it. Don't wait till they do it and then got to defend yourself. That's not going to be a good look in court.
Right. And a lot of times the abuser, see, this is what's really it mystifies people. The abuser isn't always the one that litigates. There are many examples where, and it's actually quite common that when it's the mother, because they get a lot by default. So it's often better for them to never litigate. They'll just never go to court, and they'll just control everything just because they'll say, you can't see the child. What are you going to do about it? So
Yeah.
there's even situations like that where they'll never go. You'll just be waiting forever because they just won't sue you. Now, the mediators and these judges, the ones that, focused on, oh, let's just come to an agreement. A lot of times it's because they're focused on the best interest of the parents. They just feel bad for the mom. Oh, we can't take their child, and they're putting I feel bad for mom ahead of this child is being damaged, and they don't even know they're doing it. And then the other side of that coin is the end of this idea that once you guys are done fighting, everything is magically going to get better. I don't understand why they get so fixated on this. It's nonsense, but they think once you settle and you go away, magically everything is going to be working out for this child. They're going to be happy and they're going to, it's not true all the time, and they don't seem to understand that. So I think it helps the viewers to know that you can adjust these people, the mediator, the judge. You can let them know, hey, I understand you feel bad for her, and I do too, but this isn't about what's best for the parents. And then the other
Exactly.
the other side of that coin is, I understand you guys want us to come to an agreement and leave, but just because we sign this piece of paper and go away doesn't mean this child's life is going to get better. And sometimes this connects with them, and it's other times they just don't care. Some of them are so selfish and don't want to do a job. They hate their job. They want to just get rid of you. They don't care what the truth is. They don't care if your child suffers. Let's just put it that way. The other thing that you mentioned is this high profile attorney. She's so good at winning cases and she's the best, yet she was duped. She was suckered. And I tell people the reason this happens is not so much because the abuser lies, it's because their mental health issues are so bad that they actually believe their lies. So these attorneys and judges who tell themselves that they're great at picking out liars, what they don't understand is that skill doesn't work if somebody believes their lie. When you're dealing
Right.
with a person who is telling the truth in their mind, they're going to come off convincing. And so that's how they fool even lawyers and judges. Some judges get to the point where they figure out the trick is you got to look at their actions. Because if you look at their actions, it doesn't matter what they believe. You're going to say that's obviously hurting your kid. But a lot of these other judges, especially the rookies, the really brand new judges, they think, oh, well, that story was convincing. They're telling the truth. No, they're just mentally unwell and they believe their story.
Mhm.
Yeah.
So
Well,
Yeah.
exactly.
yeah, the
And
other thing that I wanted to mention is you got a question from one of the viewers, and he says he wants to know how often. Oh, this is a Pyriute. He wants to know how often and by what means did you communicate with the GAL?
Now, in the very beginning, I didn't really communicate with the GAL too much because that was what my ex was doing. So basically, my ex was using. So by this time, when the GAL got appointed, she lost her lawyer. So the only lawyer she had was the GAL, because the GAL was technically the lawyer for my daughter. So my ex was doing was trying to use the guardian litem to tell her a lot of lies or a lot of accusations. She was basically bad mouthing me the whole entire time,
in front of
and in
the
front of the children as well. So what my advice, according to talking to the guardian litem, don't talk as much if it's not something you can prove. So if you're going to bring up something, bring up concerns, bring up evidence, but bring up stuff that's I guess what I would say is relevant and beneficial to the child, because a lot of people what they do is they and let the guardian let them know how good of a parent you are instead of how bad of a parent the other person is. I guess that's the best way I can explain it,
Right.
because when you show what you can do as a parent, that shows that you're not trying to just take the child from the other parent. You're just showing how good of a parent you are. And that's very big for a guardian ad litem, because when the other person is doing the total opposite, they see the difference. Now, like I said, I just happens to get a very good, thorough guardian ad litem, and I can't say everybody is going to have that, but I do want people to understand the way of the way of
The dynamic.
handling, yeah, the dynamics of handling a guardian ad litem, because like I said, how I did it, I looked at the guardian ad litem like they was the judge, because I felt like whatever they was going to say, the judge is going to go along with it. So I looked at them as that.
And as far as communicating with the garden ad litem, like he said, if you are uh, communicating with them, you don't want to nag them about itsy bitsy things. If the other person is calling them more so to nag about you, what you're doing, they're going to call you. And they're going to want to confirm or prove if this correct or not correct.
Yep.
And when it's proven not to be correct, and there's more to a story that the other person is complaining about, then they're going to more so get irritated with the other person, keep calling them, and it's going to sway your way more so than sway her way, because they're like, why does this person keep calling me when I'm
Yeah.
already doing an investigation? Why does this person keep calling me about this person and not, it has nothing to do with the child? Why is this person, you know what I'm saying? So I mean, just let them contact you. And if there's any concerns, then you call them and say, well, my child came over and I'm concerned about this. Can you please check up on it? And they will. Don't say anything bad about the mom
Exactly.
or nothing like that. Don't
Yeah.
call her out her name. Don't say things that you cannot prove by uh, uh, text. And
Yeah.
you print up your text. Don't try to show me your phone. That's not
Oh,
going to do.
I do want to piggyback on that too with the phone situation.
Mhm.
Yes. Now, when we first got, because we got to sign the agreement when the guardian litem is actually put onto the case, and the documents show that we shouldn't be sending any text messages, video recordings, audio recordings, none like that to her unless they're requested. So don't when you do have a GAL, do not, trust me, do not do anything against that order, because it's going to make you look bad. Do exactly what she's told. And now, if you do want to give her any exhibits, you tell her what your concern is, you tell her what you found out, and you offer. You be like, if you like, I can give you this. If you like, I have it whenever you want it. But I do have this, I do have that. Try to gather as much evidence as possible of the other party as well. But don't communicate just trying to tell and being a tattletale, basically. Don't do that. That's going to make you look like it's going to make you look just like the other person.
Just
That,
as conflict.
yeah, just a conflict. So you don't want to do that.
Okay, so a couple of comments here. It looks like. Oh, by the way, I know that these viewers ask me tons of questions about GALs, and I had zero experience. So for you to come on and give them all these details, I think is really valuable to the channel. It's just something I never went through, and I always hear bad things about GALs from my viewers, and I just don't know what to think because just I've never gone through it. But it's a couple of comments here. The first one is. A GAL as plaintiff's attorney? No, Marcus didn't say that the GAL was his attorney. The GAL is independent of both parties. So, yes, you're right. It would be a conflict of interest, but in this case, the GAL is not the plaintiff's attorney. And then he mentions one of the drawbacks to being the petitioner or the plaintiff is that the burden of proof is on you. This is actually very technical, and it does not apply very well to divorce and child custody. The reason why is, let's use divorce for an example. The person who files for the divorce does have the burden of proof, but it's not in every single thing that comes up in the case. It is only for showing whether or not they are entitled to the divorce, which all you have to do is show that there's irreconcilable differences. It's very easy to do that. No judge would ever deny the fact that parties are entitled to a divorce. Following the entitlement to a divorce, you're going to have all of these remedies that come up, like division of assets and debts, child custody. And at that point in time, the burden of proof is not solely on the petitioner or the plaintiff. So what you're saying is very technical, and it's only true under certain circumstances. It's not necessarily going to put the burden of proof on him throughout the entire case for every single issue that comes up. And the other thing is, I guess there's a Triple D says, bottom line is know the law of your jurisdiction and apply it. And that's one of the things, you had the right attitude here. A lot of people are like, well, I'm going to have an attorney, or I'm going to figure this out. I'm not going to really need to look things up. You went and did all the research. And I can't tell you how many people don't start doing research until after they lose, which is the worst thing you can do, because you can't fix it once you've lost. And so to do it ahead of time, that was the smartest thing you could have done. And one of the things I tell my viewers is you're not always going to have an attorney if it's a high conflict case, because your ex is going to continue to do crazy things, and you're eventually going to have to go back to court over and over again. And eventually you may have to actually do it yourself, because there are some people who can pay for an attorney, but they also want to be, going on vacations and getting a new car and a new house. You don't want to live a life of misery. A lot of people say, oh, you can just be on ramens. Well, there's only so long you can do that before you go insane. And it's just,
And
it's just not realistic. And so it's important that you did that research, because one day you may end up representing yourself just like I had to. And it sounds like you really understand how to objective, and it sounds like you have critical thinking skills, and so that's going to give you a real leg up in representing yourself if you ever have to do that. So at this point, we have to wrap it up. I've got to get going. I have to be somewhere at noon. And so thanks for coming on and telling everyone your story. I really do think it's going to help people a lot.
Oh, most definitely, most definitely. If anybody have any questions or anything, I can look at the live stream, and if anybody have any questions after this, just directly, well, that too. Or I can look at the comments if you have any questions. I can reply to them as well. Because I know GL is like one of those major things that people are afraid of. But the thing is, if you just understand how to utilize the GL, you'll be just fine. And I'm not going to say every GL is thorough. Not every GL is, a good GL that really takes their job seriously. But I would say just understanding how to utilize them will at least give you a little bit more of an understanding of what to do. But if you have any questions, refer to let Alex know, and he'll talk to me about it, or put in the comments. I'll look at them. But thank you so much, Alex, for really helping me out in this case and giving me the knowledge to be able to handle diversities that happen just with my ex and stuff like that, because you was a major part in just me making hardly making any mistakes, and like you said, trying to make this as perfect as possible. I don't know if people even I don't know if we mentioned this, but you want to be as perfect as possible in this case, because especially as a male, because anything you do will be 10 times worse if the female do it in a court case.
It's true. Absolutely. All right. Thank you, Marcus. I will forward any requests to you if I get them in the emails. And of course, go ahead, you can monitor the comments. I have one more comment, but it's not about you. It's a technical question. So I'll hang up with you. I'll answer this viewer's comment, and then I'll end the broadcast.
All right. Sounds good. Talk to you soon, Alex.
Thank you. Bye.
All right.
Okay, I have disconnected with Marcus. I've got a question from Jennifer. When does the burden of proof apply to child custody? It's not something that you can get a general answer to, but what I can do is give you some examples. So, for example, let's say we have two sides that want different things. One side wants primary custody, the other side wants joint physical custody. And let's say the person who filed the motion is the one asking for joint physical custody. So following what a Pyriute said, it might seem as though the person who filed that motion is the one that actually has the burden of proof. But in Nevada, we have a statute that sets a presumption, and that presumption is that two parents should have joint physical custody of the child. So because of that particular statute, the presumption is that the parent who wants joint custody should get what they want because the law says so. The other person has the burden, even though they're not the ones that brought the motion, even though they might not be the ones that filed the petition. It doesn't matter because the statute says that there's going to be a presumption of joint custody. So the other parent, despite being the non-movement or the defendant or the respondent, they have the burden of proof to overcome that presumption. I use this example because under different situations, the burden of proof might be, on different people. Another good example is burden flipping. There's sometimes a burden of proof is on one person, and then after they show something, it flips to the other person. So let's use the imputation of income example. If somebody wants to impute the other person's income, they have a burden of proof in Nevada to show that that person is willfully underemployed. Once they have proved that that person is willfully underemployed, the burden of proof shifts to the other party. And that other party now has to show that, hey, I am underemployed, but it is not for the purpose of avoiding child support. So it can start on one person and then go to the other. And again, this is because of a statute. There's a law that says so. There's a law that says that a person can only be they can only have their income imputed if they are willfully underemployed for the purposes of avoiding child support. And the Supreme Court of Nevada has stated that that burden shifts. It starts out with the person having to show that the person is underemployed, and then once they do that, it shifts to the other person to now explain themselves as to why they are not underemployed for the purposes of avoiding child support. If I can remember correctly, there might be another good example of burden shifting. Oh yes, the contempt of court against a parent who is not paying child support. The person who files that motion to hold them in contempt of court, the burden of proof is on them to show that the other person is not paying child support consistent with the court's order. Once they have shown that, once they have proven that, now the burden of proof shifts to the other person to explain to the court, yes, I'm not paying all of the child support I'm supposed to. However, I am not doing it on purpose. This is not a willful violation. This is something that I can't control. I am not working, I'm not making enough money, and now the burden of proof is on them to show they're not working, they're not making enough money. Sometimes there are things known as affirmative defenses, and those affirmative defenses require the person who's bringing up that affirmative defense to show that that's true, despite the fact that they're not the ones who filed the motion, that they're not the ones who filed the complaint or the petition. It doesn't matter because they're raising an affirmative defense, the burden shifts onto them to show what their affirmative defense is. So it's a little bit more complicated than just being the first to file, meaning you have the burden. But so we got a Pyrrhute saying here that if a party alleges a matter of fact, the burden is on them. Most of the time, a Pyrrhute, that's true. Sometimes that requires proof of a negative. So there's another exception. If you have to prove a negative that's considered to be prejudicial, what the appellate courts expect is for the other person to show that that isn't true. So, I mean, you're kind of right. Usually the person who files a motion or who files the complaint has the burden of proof on them, but not always. And even then, it's usually only to show that they're entitled to prevailing on that issue. If they show that they're entitled to prevailing, now the court has to figure out what's the remedy going to be. At that point in time, things change. Because now, like going back to the divorce example, somebody files a complaint for divorce. They have to show the burden of proof is on them. They have to show that they're entitled to a divorce. Once they have shown that, the court goes, okay, you're entitled to a divorce. You've proven it. What are all the remedies involved? At that point, everything changes. Now the burden is no longer on a particular party. Now the court is providing a remedy. They're dividing assets. They're dividing debts. They're awarding custody. So these things, it becomes fuzzy. And what the court's going to do is, take evidence from both sides as to how they should fashion some kind of solution to this problem, which is in this case divorcing, and how they're going to part ways financially as well as in real life. Anyway, I think I've given. Sometimes my explanations can be confusing, but it's okay, because what that tells people is this is not something that's very simple, and I'm going to have to look it up. And it's okay if my viewers come to that conclusion, hey, I'm going to have to go look something up because it's complicated. Not everything is very quickly and easily explained. So thank you guys for coming on to the live stream. I'm going to go ahead and end the broadcast, end the stream, and I will see you guys next time.